People v. Emmanuel Diaz, number 9. Oh, grand. Thank you.
May it please the court, my name is Dina Zogzauer and I represent appellant Mr. Emmanuel Diaz. With Your Honor's permission, I'd like to reserve 2 minutes of rebuttal time.
Yes, counsel.
The people violated appellant's rights when they obtained recordings of his phone conversations from Rikers with family and friends, absent any consent, prison-related purpose, or a warrant.
Counsel, as I understand it, your argument's grounded in the Fourth. We have a number of different arguments here about Rikers, but your argument's grounded in the Fourth Amendment, right?
Yes, Your Honor.
So could you just explain for me, it's grounded in the Fourth Amendment on this is ineffective consent for Fourth Amendment purposes?
Yes, Your Honor. For purposes of the dissemination of the calls, the...
Could you give me any other situation in which consent, other than physical, you can search my bedroom, you can't search my living room, consent to use of the tapes would be something that we would look at? And because generally when I think of limitations on consent, I think you can look at my trunk for body, or you could search my living room but not my garage. So how is this a limitation on the prison can use this and no one else can?
The prison or the district attorney's office?
The prison. I mean, I assume your argument is I'm only consenting to the extent the prison can monitor my calls for prison-related issues, security, et cetera.
Well, a couple things. First is that the notice provided to the inmates at Rikers used the word consent. It's the Department of Corrections that says that, by using the telephones, you are consenting.
So if the NYPD asks me if I consent to search the house and I say yes, then later I can say, but I only gave the NYPD consent to search my house. You gave it to the FBI.
No, that's not quite what is at stake here. First of all, the Department of Corrections, as this court has said in Johnson, is not an agent of the district attorney, whereas a police officer is obviously part of law enforcement and
right. But the point I think that Judge Garcia is asking you about is, once you have given the consent to the search, you lose the right to control, once that evidence is seized, how that seized evidence is disposed of.
Why? I beg to differ. When the notice provided is limited to you are consenting to the use.
So give me, and I think that's what Judge Garcia was asking you at the outset is, so where are the cases that suggest that that's wrong, that you lose control of the items seized?
You don't lose control of the items seized. You can use the items. I am not challenging the use of the items by the Department of Corrections. What isn't permissible, what the law doesn't provide for, is that that is then turned over, subject to no consent.
That's not a loss of your expectation of privacy once you've done that?
No, Your Honor.
Are you familiar with our case in Bushy? It's a recent case where we held that information that a motorist gives to the Department of Motor Vehicles, that there's no expectation of there's no expectation of privacy that would prevent the police from accessing that information and using it to prosecute a motorist.
And again,
why is that different?
Maybe the relationship between the Department of Motor Vehicles and the police is different, but this court has said multiple times now that the Department of Corrections is not a law enforcement agency. You've said it in Johnson, you said it in Kelly, you said it in Howard, you've said it again and again. What is happening here goes well beyond what the purpose of the recording and monitoring
Well, counsel, at its essence,
yes.
What is consent? Doesn't one have to understand what one is consenting to?
Yes, Your Honor. One has to...
Let me ask you this. Could the Department of Corrections have said, we want to record and monitor because we want to take home the tapes and listen to them with our kids. Could they have done that?
I think that that would not be permissible because every court in the country that reviews prison regulations reviews it under the safety and security purpose standard. And just for
So the authority is based on the fact that DOCS runs a particular facility, and it's whatever supports the penological interest in that facility.
Precisely. And so the recording and monitoring of those calls serves that purpose.
Well, suppose that a call that's recorded has evidence that an inmate is planning and has a concrete plan to bring a weapon in. In that circumstance, can the call be turned over to the police?
The operations order that governs this recording and monitoring provides for an instance like that, bringing in contraband, planning for escapes. Those would all fall under that purpose.
All right.
How does the
And
defendant
And what if he
know
just
that?
says, you know, I want you to go to the victim's house, who happens to be his girlfriend, and tell her this, that, and the other thing, you know, so that she doesn't testify.
Witness tampering, sexual abuse are all examples of criminal activity that could be occurring within the facility, that are new crimes that definitely are part of
But
that
that's not
umbrella.
gonna, that doesn't affect the facility. It affects the DA's ability to prosecute the case. So that information is going to be turned over to police and the DA's office.
Right, but that turning over to the police and the DA's office and what they do with it is subject to the Fourth Amendment, and not just...
So in that hypothetical where he's overheard to say, you know, go beat her up, tell her she better not testify, she better not cooperate. In that example, they would have to get the warrant before they could turn that over to the DA and the police?
So that's a great example. If I may use this example to illustrate my point. The operations order provides for monitoring when the prison authorities become aware of criminal activity, for example, the ones that you just mentioned.
But
witness
I'm a
tampering.
little less concerned about the operations order, but rather what the Fourth Amendment requires in that
So once that
hypothetical.
happens, they can monitor and listen to the calls. That's then a search. Then they are free, of course, to call law enforcement and to have that
Is
investigated.
the
and where
defendant aware
necessary.
of the operations order? Do they know about that operations order? Is that somewhere in something they get?
They get a handbook, and they are asked to sign page 43 of that handbook, which explicitly limits the whole regime of recording and monitoring to security purposes. I'm not sure they handed over the operations order.
Right, but they don't know they're going to hand that over to the DA, so I think under your theory, it's only what they know they can consent to. So unless it tells them in this operations protocol, we're going to hand this over to the district attorney and you're going to be prosecuted for, how do they know that? They still only know it's being monitored for the prison and for prison reasons. They don't know what they are. So to take your informed consent view to its logical conclusion under that situation, Judge Wilson and Judge Feinman's hypotheticals, they can't use the tapes. But
Let me just follow up and ask you, when we say they can't use the tapes...
they can't turn them over to the district attorney's office. I mean, maybe they could use them internally for security reasons, like to
Well,
prevent
if
a
we-
riot, but under your scenario, the defendant doesn't know it's possible they could turn the tapes over to the DA in that case, doesn't say that.
No, it doesn't, well, at least not in the notices, the three types of notices
And isn't that what
provided
you're
to them.
relying on? That's all they have notice
That is what I'm
of.
relying on, but what
I'm a
this...
little confused. I thought you said the consent is based on the internal security
The co-
in the facility. How is an attempt to use facility equipment to commit a crime not implicating the security in the facility?
It absolutely is, and that's why the operations order in Johnson says that there is a need basis for monitoring. Then the calls get recorded. It is separate and apart from a search that was done here. Here, there was no indication of criminal activity whatsoever. There's no record basis that the Department of Corrections listened to these calls. The district attorney asked for the calls at some point, we don't know when, based on no reasonable suspicion, on probable cause or reasonable suspicion that anything, that my client had said anything that
So
would
if
trigger monitoring.
if the person is taking affirmative steps to obstruct justice in the case, you could turn the tapes over. But if the person is just talking about the case and making incriminating statements, you couldn't turn the tapes over.
They weren't even aware of what my client was saying until these tapes were turned over and
That's kind of a
searched by the
different issue.
But
let's go back to the hypothetical. If I listen to the tapes and I'm in the prison and I hear the client talking about the case, the defendant, he's talking about his case and making highly incriminating statements, I can't turn those over. But if I hear him talking about somehow tampering with a witness, I can turn those over.
The question is not what you can turn over or not. The question here is whether the consent based on the notice provided to the inmate, limited to security purposes.
Okay, so I'll rephrase the hypothetical.
extends to the
So now we have these two
prosecution.
sets of tapes. And one is, I'm talking about the case and I'm a defendant, I'm talking about the case, I'm making incriminating statements. I haven't consented. But if I'm on the phone and I'm talking about interfering with a witness, I have consented.
You want to start the analysis at a point that is at the Department of Corrections. I'm asking that you look at it from the District Attorney's Office. May the District Attorney's Office seize those recordings, absent any indication of criminal activity occurring within the facility
But how can you
involving
not
that inmate?
start it with the Department of Corrections? Because that's, that's who is doing the recording, that's who they've consented, and
Yes.
that's when, the question is, what's the expectation of privacy? And have you basically waived that expectation of privacy? Now they have the tapes because you've consented.
But we don't
I think
waive.
we're all suffering a little bit with
Let me ask this
we
question. Can
don't-
I ask a question?
Sure.
Yes.
There's been a change, I understand, at Rikers now, and now law enforcement agencies are part of the notice that's given. Is that correct?
Footnote 4 of the People's Briefs on page 16 suggests that, and it says that it may turn over to law enforcement.
All right. In the appellate division decision, they recommended that and said that would be better practice.
Yes, and in fact, this court left that open in Johnson as well.
Let me ask you this. Does that meet the notice requirements necessary for the recordings to take place? In other words, that inmate then is on notice that this information can be turned over to law enforcement in Rikers Island now.
I think that from its inception, the absolute unfettered access to these recordings, absent probable cause or reasonable suspicion.
I'm not talking about these
even with
recordings.
notice like
Slow
this-
down. I'm not talking about these recordings because these recordings were made without that notice. I'm talking about if the notice included a reference to law enforcement, because there are other prisons in this state than Rikers. Would that be sufficient to constitute consent for turning over those recordings to law enforcement agencies?
I think that the phrase within the brief, if that's the phrase that's actually used, is too vague. I'm not a lawyer for the
All
Department
right,
of
all right,
Corrections.
you're saying it's too
but-
big, but if you say, forget about the wording of the phrase.
Okay.
The concept is, if they tell you, and you're going to go use the phone, we could record this and give this to the police, is that sufficient consent?
I think the only phrase that would ameliorate the problems in this case would be a phrase such as, we are going to turn over your phone calls with your family and friends discussing your pending case, whether you can make bail, which is what happened here, whether you should hire an attorney,
Well,
which is what happened here.
it's a great deal of detail that you're asking for on consent on notice. I forget about the words for a second. The concept itself, though, that law enforcement, that an inmate is told that if you open your mouth on this telephone, that this information will be given to law enforcement. And you're consenting to that by using this phone.
I think the phrasing has to be a little more as in Miranda, so that...
That's fair,
Yes.
but as a concept, you're not saying that concept is in and of itself incorrect. That can constitute consent. Is that fair?
Department of Corrections itself relied on notice and consent as an exception to privacy rights of the inmates. Yes, if there were a more specific notice,
So
then we can say that there was knowledge.
Keeping alive
and yes, there
your
was
question about the quality of the notice itself can be sufficient if you tell the inmate that this stuff can be turned over to law enforcement. Now, I'm not saying you're committed to wording, but that concept itself. So the question for us then should be, if this consent of information is actually being done in Rikers, why isn't it being done in every other jail throughout New York State? Isn't that the question?
That is one of the questions.
Well, just on this question of notice and consent.
Yes.
Because everything rises or falls, it seems, in your case on that question.
Yes, it rises and falls on the limitations of the
Well,
notice
the adequacy
provided
of the
to them.
notice, sure.
Yes.
Right, thank you.
Okay,
All right.
thank you, counsel. You have rebuttal.
May it please the court, my name is Leonard Jobla for the respondent. The recordings of the defendant's telephone conversations were properly admitted at trial because, given the 3 forms of notice that the defendant received before he picked up the phone and made the call, he impliedly consented to the recording and monitoring by the
Why
Department of
isn't
Correction.
that consent limited to use by the facility for its own security purposes?
The short answer, Your Honor, is because there was no such limitation stated in any of the notices given to the defendant. The defendant received 3 forms of notice. The only one that contains any language that provides even an argument to suggest that there's some limitation on the use is the notice that appears at page 43 of the inmate handbook, which says that the calls, other than privileged calls to attorneys, physicians, and clergy, may be monitored by the department for security purposes. And that language is being construed by the defendant as a limitation on the use of the evidence.
Well, no. Someone who is able to read that, and they read that, how would they believe that that means, oh, if I'm talking about my case, that will be given to the person who's prosecuting me? How is that about the security purposes in that facility?
Well, that, Your Honor, that's describing use or potential use of that information, but this notice is a notice of what's the nature of the intrusion here, and
No, the notice is saying it's going to be recorded and monitored for security purposes. That is docs defining what I believe under the law is the only basis by which you could record and monitor for security purposes.
well, that's
And that's
the-
what you've informed. These are pretrial detainees. These are not people who are yet been found guilty. These are people who can't make bail, so they can't be out where the DA would have to get a warrant. Okay. So how would one who gets this notice understand it to mean it's going to be used for something other than ensuring the security of the facility?
The point is that what they understand through these notices is that their conversations are going to be recorded and monitored. The statement that it's going to be for security purposes is providing some notice about the extent of the intrusion. And if I could give a hypothetical example to illustrate the difference between a statement of the,
Well, the intrusion is everything is recorded.
and that would be a different,
There are no variations there, and there's no degrees. They're not recording, the AM phone calls, but not the PM phone calls, the first 2 minutes, but not the rest, right?
yes, Your Honor, that would be a different way to say the same thing, which is all of the calls are being recorded and all of the calls are being monitored. That would be a different way of saying the same thing as opposed to saying,
For security purposes. It is circumscribing the action by the facility.
well, it's circumscribing what the facility is doing and what the nature of the intrusion is. If they said it would be monitored and recorded for purposes of making sure that the phone system is working, that might suggest some kind of intermittent check, as opposed to saying, in fact, why is the department recording
Isn't
this?
another way of looking at it, so the for purposes of gives their rationale, but it's not really meant to limit, either the scope of the intrusion or once you've had the intrusion and you've seized the tape, it's not a limitation on how you dispose of what you've seized.
Yes, Your Honor, I agree with that. And to give an example in a different context, if a police officer approaches someone and says, I have some information, and based on that information, I'd like to search your home for guns. Do you consent? And the person says, sure, come on in and take a look in my home. If the police officer goes in there,
Finds a kilo of cocaine while looking for the guns, it's fine.
as long as it was in a location where the officer was authorized to look for
Right.
guns.
And of course, the problem with this hypothetical that the people continue to use is in that example, the person is completely in a different situation than a pretrial detainee who can't make bail and is on Rikers, which is basically hell on earth. These are two different situations.
Certainly,
Correct?
Your Honor.
All right. So what they are being informed at Rikers is not that this is what we're doing, we're going to record and monitor for this purpose, and the individual you argue, impliedly consents not only to the recording and monitoring for security purposes, but that they can then do anything they want. They can burn that CD and do whatever they want with it. Under your scenario, they could take it home and listen to it with their kids. You say there's no limitation on the use. But that individual cannot, unlike the hypothetical you were using, turn around and say, I have alternatives to communicate, and I'm going to rely on those, so I'm going to circumscribe my consent. These are not the same people that you're referring to.
Was the argument about the fact that he was detained without bail actually preserved in this particular case?
No.
I'm talking about the next one, in Diaz.
The only argument that was preserved was a claim that it was a warrantless search without consent in violation of the Fourth Amendment. So to the extent that there's some language in the defendant's brief which at least suggests an equal protection due process claim raised on issues about indigency versus wealth, that claim is not preserved.
Counsel, I think you misunderstand me. My point was that the hypothetical you were using does not work here because you're trying to compare individuals in very different situations and very different expectations, and that was my point. And
Yes.
I wanted you to please respond to how, even with those differences, these differently positioned individuals, you think the rule is exactly the same.
Well, no, Your Honor.
That was the point of your hypothetical. The rule is exactly the same.
Well, the situation is certainly different, but the notion of a difference between a notice about what the purpose of the search is in defining and giving notice to the person who may or may not consent, what the extent of the intrusion is going to be. The intrusion here is the listening to and the recording of your phone calls, which is a different question from use that might be made of the information after we obtain these recordings.
Could you-
And so...
You agree there's nothing in the notice that explains what will be done with the recordings and whether or not they will be shared with others. At the point that this case came up, not now.
Yes. I agree that there was no such notice, but no such notice is required in order to have valid implied consent. And this really goes to the third-party doctrine, which was addressed by the Supreme Court in Carpenter, and which the Supreme Court in Carpenter recognized is still the law, and that has been applied in the cases of I provide personal financial information to a bank, and even if the bank didn't tell me, and obviously now there are privacy notices given, but even if the bank didn't affirmatively tell me, you realize if we find
It's hard to deal with that analogy when Docs is not a bank. You don't get to choose what facility and whether or not you can or cannot do certain things. In terms of what alternatives you have, you always have an alternative in your example.
Well, that's correct, but we're talking about whether there has to be affirmative notice in order to have relinquished your expectation of privacy. And
Well,
if
let me ask that. Does there? That is, could you have tape recorded or monitored the calls without posting any notice whatsoever? For security purposes?
No, Your Honor, because for one thing, that might constitute a violation of the wiretap.
Let's leave the wiretapping out for a minute, for Fourth Amendment purposes.
There would not be a valid waiver or consent if there's no knowledge on the part of
So the consent, there's an expectation of privacy. Therefore, if you're saying consent is required, then you must be saying that there's an expectation of privacy, right?
Oh, certainly. Yes, Your
Okay,
Honor.
so there is an expectation of privacy that the prisoner has in the phone call, and you're saying consent, so really we're just down to the adequacy of the notice required to give consent. Isn't that really what we're talking about here?
Yes.
Isn't this in some ways a much narrower issue than it's been briefed and argued about, even among us in our cases? At this particular moment, it seems that what we're really talking about is, was the consent sufficient? And then we're down to the language on the consent form, and whether or not that's sufficient.
Well, yes,
And
and-
it seems that your office has recognized, we can go a little bit further than we had gone before, and you made note of that in your brief, by making reference to law enforcement agencies.
Certainly, the Department of Correction has recognized that, and apparently that change was implemented subsequent to this court's decision in Johnson. So, right, more notice is always better in terms of ensuring that the inmate defendant is as fully informed
So
as
let
possible.
me ask you this. Notice that tells a prisoner that he's being listened to and that information can be turned over to a law enforcement agency. Would you say that's sufficient? That notice is sufficient to breach his expectation of privacy? Eliminate.
Where there is express notice that
Right.
it can be turned over, that's
Right.
more than sufficient, because here there was no express notice of that, but just like, and I take Your Honor's point, that the person at liberty putting money in a bank is in a different situation than a pretrial detainee at Rikers, but still, the point is the same, that there doesn't have to be explicit notice that if you talk to any civilian and reveal information that's incriminating, they don't have to tell you right before you talk to me, I have to let you know that I might turn over incriminating
You're saying,
admissions.
you're arguing the third-party doctrine, basically, you turned it over to them so I can do whatever I want with it then.
Well, subject to other legal limitations. but-
The problem with that, and this is why I think you've wisely, and the department has wisely required consent, is that at Rikers you have a hodgepodge of population, but when you're dealing with someone who's a pretrial detainee, then you're still dealing with the presumption of innocence. And in that context, it isn't the same. And the barrier, I think, is much, much higher for you at that point than it would be, say, post-conviction, so.
Yes, and there are.
Consent that's required.
Yes, a pretrial detainee who
Right.
is presumed innocent, but under the law has been lawfully deprived of his or her liberty,
Well,
and there are
it's-
certain incidents.
There are a real practical element here.
Are you agreeing that there's a distinction to be made about how you can consent between pretrial and post-conviction detainees? I don't think that's what you meant to concede.
No, I'm saying
I
there's a
wouldn't
difference.
see- I don't see the rationale for that.
There's a difference in the status of the convicted defendant
Well,
as
sure,
opposed to
there's
the
a difference in
pretrial
status, but
detainee.
either you consent or you don't consent.
Well, this is a question of, has there been adequate notice given to the fact that the call is going to be recorded?
Counsel, the Chief Judge is going to try.
I'm going to try to get a question out, and it might only be a curiosity. Was there a motion to suppress made in this case?
Apparently not, Your Honor, and
Is
certainly-
that the practice in Brooklyn?
Ordinarily,
You didn't object, right? You went forward?
correct. This appears to have been treated as a motion in limine regarding the admissibility of the recorded Rikers phone calls. It certainly appears that the better practice should have been, to the extent this was a motion to suppress based on Fourth Amendment grounds, should have been done pursuant to Article 710 of the CPL.
One would think.
Yes.
Yes.
Thank you, counsel.
Thank you.
So why doesn't it have to be a motion to suppress under CPL 71030 or a motion to preclude because you didn't give notice within 15 days of your intent to use this?
The issue was fully before the court, in whatever format it came before the court. The court ruled on it. Counsel preserved this issue fully and completely. There was, if we're just limiting ourselves to what format is being used to discuss whether or not these calls are admissible at trial, then we're not giving the parties an opportunity. We're just limiting the format, we're not really.
So when did counsel learn for the first time of the existence of these statements?
I unfortunately don't know the answer to that, but I do know that the practice in New York, in the city, is that these are turned over relatively late, towards the eve of the trial. So I don't think it was turned over at the earliest stages of discovery.
Counsel, can you address the third-party doctrine
Absolutely,
argument?
Your Honor. Yes, it's critically important in this case, this idea that when you agree, consent to the disclosure of deeply personal information, such as these recordings, and I don't think anyone disagrees that these are deeply personal, private conversations with his father, with his girlfriend, with his mother. When you agree that these can be recorded, and monitored when there's a need in the Department of Corrections, that it doesn't mean ipso facto you have now disclosed it to everyone, including the prosecution. And that's exactly what the Supreme Court said most recently in Carpenter. It's also exactly what this court has said in Weaver in 2009 with GPS.
Counsel, you would agree, though, if we were to find that the consent was legitimate, which would make the interception of the conversation lawful, that after the lawful interception, this is about the defendant's reasonable expectation of privacy, correct?
Correct?
Okay.
Yes. If the interception was lawful, that doesn't mean, though, that he's now waived his expectation of privacy to everyone else. Just like if you disclose your self-site information to the mobile carrier in Carpenter, that does not mean that the government now gets to
Well,
obtain
Carpenter
that
was a
information.
little different because in Carpenter, I think the court held that, or commented that there was no notice and that there was nothing that it wasn't an affirmative action on the part of the user to actually use the phone. The collection of information happened merely by having the phone.
Actually, the court did not decide this on the lack of notice or notice. The court decided on two factors. One is the breadth and depth of the information obtained. The quality of this information was so private.
Mr. Carpenter didn't have a reduced expectation of privacy in his actions, correct?
He had a reduced expectation of privacy in the same sense that this court considered...
The same sense as a prisoner?
No, in the same sense as we all do when we go out into the public. The courts have always said that we have a reduced sense of expectation. In Riley, the Supreme Court said, yes, when you are arrested, you have a reduced sense of expectation, but it doesn't mean that the police get to search your cell phone. So, that's the holding in Riley. The holding in Weaver, the 2009 decision by this court also says, yes, you have a reduced expectation of privacy when you use the public roads, but it doesn't mean that the government gets to obtain your GPS information.
I know your red light's on, but I just want to clarify one point. In this case, Diaz, that there was no argument made, and there's no argument being made under the state constitution.
No, it was raised both by the state and federal constitution, by the defense counsel, yes.
Okay.
He specifically mentioned Article 1, Section 12.
So what would be the specific argument that the right here is broader under the state constitution than the federal right?
The court applies a more generous Fourth Amendment protection and has
Under consent, what about Badalamenti? Didn't we adopt, over my objection, a federal rule about vicarious consent that is broader?
I'm not familiar with that case, but the bottom line here is that the inmate didn't just read the notice. They were asked to sign it. I refer to page A236 of my appendix. The staff member of DOC comes and testifies, and she says the following: the first means of notification is the inmate handbook, which they must sign for during the intake process. On page 43 of the inmate handbook, the last paragraph, it states that all calls may be recorded for security purposes. It wasn't just reading, it was signing. And then I just also want to point out—
Counsel, thank you.